The Appellate Division, First Department is now in session. Good afternoon and welcome to the Appellate Division, First Department's virtual oral argument. I will now call the calendar. People versus Donald McLaurin.
Matthew Bova for Appellant Donald McLaurin. I'd request 4-1, Your Honor.
Okay, you have 4-1. Respondent?
Patricia Kern for the people, Your Honor. 5 minutes.
You have 5 minutes.
Thank you.
Plotch versus 435 East 58th Street.
Adam Plotch, appellant, Your Honor.
You have 5 minutes. To respond, what did you want to say?
Each of the respondents was allotted 5 minutes. They each have separate arguments. To balance it out, could I get 10 to counter the 5 and 5 with that?
We'll start with the 5 and see whether we need more time with your argument.
Thank you.
The defendant, 435.
Yes, for the call-up respondents, Tracy Peterson of Braverman Greenspun.
Okay, you have 5 minutes.
Yes.
Respondent J.P. Morgan.
Brian Scabetta from McCalla, Raymer, Lieber, Pierce. I believe we have 5 minutes as well.
Correct. You may not need all that time, neither of the respondents. Crawford versus Brezhnev is submitted. Deshane versus Tricon Construction.
Good afternoon, Jonathan Glasser from Lester Schwab, Katz and Dwyer here for CP Plaza and Tricon Construction, Your Honor.
Okay, you have 5 minutes. Is Respondent Boyle the next one that's going to argue?
I'm here, Your Honor. This is Sarah David for Respondent Boyle. I am supporting the appellant's position, so I defer to the court as to the order of the respondent's arguments.
Okay, you have 1 minute.
Thank you.
And then you will follow the appellant. You say you're supporting the appellant, so you'll follow the appellant. Is the plaintiff going next?
Yes, Your Honor. Kenan
Mr. Goldblatt? Mr. Goldblatt, you have 5 minutes.
Thank you, Judge.
Is Dollar Tree last? Shannon Sachs? Mr. Sachs?
She was on earlier and advised that she had not submitted papers and was told that she could not argue. If she's permitted to argue, I believe she could get back on.
She can argue for 1 minute.
I'll let her know. Thank you.
People versus Smith submitted. People versus Bernstein submitted. Hudak versus Good Samaritan. Respondent, appellant Good Samaritan.
Good afternoon, Your Honor. Duraba LaSalle of counsel to Raskin Morelli for Good Samaritan Hospital. I believe I have 5-1.
Oh, actually, you had 6-1.
Oh, I'll take it.
You don't have to. Appellant Ramapo.
Yes, Catherine Herr Solomon for Ramapo, OBGYN, and Dr. Panoff. I believe I have.
You have 8-1.
Right. Thank you.
Appellant Solomon. This
is Danielle Bennett with Costa Brady and Nagler.
So you have 8-1.
Thank you.
Respondent appellant plaintiff Hudak.
Brian Isaac, Your Honor. I think I have 5-2.
That's correct. And Respondent Vinnick. Is Respondent Vinnick present? Well, actually, this case is going to be argued first because Justice Schulman has recused himself. Justice Gish has been vouched in. If there's a tie vote, a fifth judge will be vouched in. If Mr. Vinnick arrives in time to argue, we'll take him. Otherwise, he will. I don't Mr. Vinnick, I mean Mr. Respondent Finnick. If his lawyer is here, he can argue. If not, we will go without it. ECD New York versus 616th Avenue.
Good morning, Your Honor. Ira Schulman from Shepherd Mullen for the appellant, request 6 and 3.
Okay, that's granted. Respondent?
Benjamin Ratner for respondent ECD.
You have 9 minutes.
Thank you, Your Honor.
TCR Sports versus WN Partner. Appellant?
Introducing Carter Phillips.
I'm sorry, I cannot hear you.
Jonathan Schiller, Boy Schiller Flexner for Mazin and the Orioles, appellants. I'm introducing Carter Phillips of Sidley Austin, who will argue, Your Honor.
Okay, you have 8 and 2. Respondent?
Good afternoon, Your Honor. Stephen Newworth from Quinn Emanuel, Urquhart and Sullivan for respondent.
Okay, you have 10 minutes. I am recused on this case. Justice Renwick is vouched in. If there's a tie vote, a fifth judge will be vouched in. This case will be argued last because it's how we get Judge Renwick into the Teams meeting, and that's why we're taking Hudik first. How we get Judge Gishin, and it just works best for us that way. People versus Powell submitted. Chiron versus NYCHA submitted. Pullins versus NYCHA.
For the New York City Housing Authority, Andrew Amupin.
6 and 2. 6 and 2. Respondent.
Emma Rosenberg for the respondent.
6 minutes. People versus Rogers submitted. People versus Rositas submitted. Winston Capital versus Kirschenbaum.
Yes, Your Honor. Daniel H. Richland for the appellant. Could I have 3 and 2?
Yes.
Thank you, Your Honor.
Is the respondent here?
Yes, Your Honor. Ori Nazarian for respondent.
5 minutes.
Thank you.
U.S. Bank versus Rivera submitted. Raffalo versus Thompson Asset submitted. Rodriguez versus Extel submitted. Hudik versus Good Samaritan. The appellant may proceed.
Good afternoon.
Your Honor, I just want to check Joshua Cohen. I got logged out twice. I want to make sure that I can be heard.
We hear you, yes.
Thank you, Your Honor. Good to see you.
Go ahead. You may argue.
I'm a respondent. I'm waiting for appellant to start.
We're the appellant.
Oh, I apologize. My microphone is off. Can you hear me?
Yes.
Thank you. Good afternoon, and may it please the court, Duralba LaSalle of counsel to Raskin Morelli for defendant Good Samaritan Hospital and appellant. Appellant Good Samaritan Hospital appeals from an amended verdict after trial or judgment entered on April 26, 2019, and asks that this court remand the case to the trial court and it be retried after the hospital. Specifically, the trial.
Let me stop you. Yes, I just wanted to be sure that Judge Gish was. I see she's here. Go ahead. Yes, go ahead.
Listening intently.
Yes, go ahead.
Thank you. The trial court erred in determining sua sponte that Good Samaritan Hospital was vicariously liable for the defendant's physicians as a matter of law, thereby directing verdict against Good Samaritan Hospital and in favor of the plaintiff respondent. Specifically, the trial court's determination did not follow a request by either plaintiff's counsel or counsel for the co-defendants and third-party defendant, nor could they, because at that point in time when the verdict was directed, Good Samaritan Hospital had not yet rested its case, which is specifically in contravention of CPLR Rule 4401, which requires that any such application be made at the close of evidence presented by the opposing party. Here, the court granted essentially a directed verdict against Good Samaritan Hospital and in favor of the plaintiff before Good Samaritan Hospital had an opportunity to finish its inquiry and close its case. The notion that Defendant Panoff had requested a directed verdict is a complete fiction. Defendant Panoff did make a pre-trial in limine application for a finding of vicarious liability against the hospital, and that application was denied by the court. At no point in time thereafter did Defendant Panoff, nor plaintiff, nor any other party request that the court make a finding or determination of vicarious liability against the hospital. They did oppose the hospital's request for a directed verdict, which I will get to in a moment, but they themselves did not make such an application. And I argue that they could not have at that point in time because, again, Good Samaritan had not yet rested.
Panoff, Judge Friedman, Panoff was in the hospital at that time. Is that correct? But there'd been a previous relationship between the decedent and Panoff before.
That is correct.
This wasn't the first time. This wasn't the first time the decedent was seeing Dr. Panoff.
Correct. Dr. Panoff was.
You're not being heard. Is your microphone muted?
Of her. Can you hear me?
Frozen.
Now we can.
Yeah.
Okay. Dr. Panoff was on call for both the hospital and the group on the night in question. Can you hear me?
Yes.
Yes.
Okay, I'm sorry. She was on call for both the group and the hospital, and the patient, the decedent, had been a prior patient of the group for 10 years prior to the night in question.
Can't hear you again. We're not hearing you.
Can you hear me? Hello?
No. Now we can. Now we can.
Dr. Panoff had delivered her prior pregnancies. At least 2 of her prior pregnancies were delivered by Dr. Panoff as well.
Go ahead.
Okay. So again, on this first point, in terms of directing verdict against the hospital, it was wholly inappropriate at that point in time to do so because the hospital had not yet rested its case, nor had any party requested such an application. Going on to my next point.
What's your position on the merits, though, about what the determination should be?
And Your Honor, thank you. That's my second point. My second point being that the hospital, at the conclusion of plaintiff's case, requested, made an application for a directed verdict, and it's our position that which was denied, and it's our position that that application should have been granted because plaintiff did not make a prima facie showing of entitlement to judgment as a matter of law. Again, this court in particular has previously held in the matter of Schiffer versus Speaker, 36 AD 3D 520, that the issue of vicarious liability is one for resolution by the jury, by the trier of fact. It is our position that there was sufficient facts in the record to dispute a finding of vicarious liability against the hospital, but essentially the jury was never allowed to render a decision on that point.
So just so I understand, is your position that the issue should go to the jury, that would be the proper outcome for the issue to go to the jury?
At a minimum, it should have gone to the jury, but it's our position that there were sufficient facts in the record to direct verdict to direct verdict in favor of the hospital.
So why don't you address that particular argument?
Sure, absolutely. Again, here the claims against Good Samaritan Hospital are purely vicarious in nature on the basis of ostensible agency and apparent agency. The law requires that there be a showing of words.
Not hearing you.
Principal, here the hospital. Can you hear me? Hello?
Now we hear you.
Okay, I apologize. The law requires that there be words or conduct by the principal, here the hospital, communicated to the third party, in this case the patient or the decedent, which gave rise to this appearance or belief that the non-employee physicians were acting on behalf of the hospital. Here,
so let me ask you something. This is Judge Kern again. Yes. The fact that the patient was brought in through the emergency room and not brought in as a patient of this particular doctor, isn't that enough by itself for this issue to go to the jury on whether or not there's vicarious liability?
Well, at a minimum, certainly it should have gone to the jury, but the Meduba line of cases do not hold that the mere presentation of a patient through the emergency room imposes a strict liability on the part of the hospital. Certainly, at a minimum, it should have gone to the jury. But again, the facts of this case were such that there was sufficient evidence in the record to support a finding in favor of Good Samaritan Hospital and against the plaintiff.
Do any of my colleagues?
Not both ways. There are some facts that are in support of your position, some facts that are in opposition, and to me that seems like jury.
And certainly, Your Honor, I'm not disputing that point. Again, my position is that at a minimum, the issue should have gone to the jury, but certainly we submit that there was sufficient evidence in the record to support a finding in favor of the hospital. And the fact that it was taken out of the hands of the jury in and of itself was reversible error. The hospital was essentially cut off at the knees.
Do any of my colleagues have any further questions? Thank you.
Thank you. I'll rest up my brief with the exception of any rebuttal.
Appellant Ramapo.
Good afternoon, Your Honors. Catherine Herr-Solomon of Morrow, Lilling, Naparty for Dr. Panoff and Ramapo Valley OBGYN. Briefly, to address my adversary's argument concerning the vicarious liability, it's our position that the trial court's ruling was appropriate and the critical facts are not in dispute. She entered through the emergency room. She did not seek a doctor of her choosing. It was a coincidence that Dr. Panoff happened to be the hospital's on-call OB that evening.
Yeah, this is Judge Kern. What about the fact that she actually contacted, though, her doctor before she went to the hospital?
Well, there is testimony that her husband asked someone. I believe that's the testimony. The patient didn't contact her doctor. There's testimony that the husband may have tried to contact that practice knowing that they were in the area, but at that point, her care had been completely transferred to Dr. Devine. I'd like to focus unless there are any other questions on that issue, I'd like to focus my argument on the trial court's error in eliminating the evidence that the decedent suffered an amniotic fluid embolism. The trial court instructed the jury not to consider any evidence that the decedent suffered an AFE, and all of the testimony was to be not considered. This was a severely prejudicial error to Dr. Panoff and all of the defendants. It was Dr. Panoff's working diagnosis that the decedent suffered an AFE. So the fact that the trial court may have disagreed with that opinion was not a basis to eliminate the evidence and the testimony from the trial.
Prior to the trial, did the plaintiff raise any issue about that defense?
No. Right. So it was a very untimely motion to seek to preclude the evidence because years before the trial was in 2018, and in 2012 and 2015 and 2016, the expert disclosures were provided to plaintiff, and it was very clear that the defendant's proximate cause argument was that the decedent suffered an AFE, therefore anything they failed to do or did not or departed from accepted practice was not a proximate cause, and that the decedent suffered the effects of an AFE, which was beyond their control.
Did the doctor testify at a deposition? I'm sorry, Judge Freeman, this is Judge Fuller. Did the doctor testify at a deposition?
Yes, Dr. Solomon's deposition was in February of 2016.
I'm talking about Dr. Panoff. Did Dr. Panoff testify?
She did. Yeah, she was deposed, but it's not clear.
Did she testify as to her working diagnosis during her deposition?
I assume that she did. Unfortunately, it was not part of this trial record. But it's interesting to note that even plaintiff's expert witness disclosure, which was in 2014, anticipated the defense Specifically, it's quoted in their expert witness disclosure. So yes, I guess the initial argument is that it was a very untimely motion.
The court's reason for not allowing the testimony because there wasn't evidence of hypoxia, right? But there was evidence which explained why that symptom may have been missing.
Exactly. I'm not hearing you. I hope you're hearing me.
We're hearing you.
Okay. Yes, I mean that was a factual disagreement as to the opinion, which goes to the weight of the testimony, not to the admissibility. And the explanation for the patient not being hypoxic was that because she was intubated, which happens to be a very unusual circumstance in a labor and delivery case. It's very unusual that the mother is intubated prior to delivery. In this case, the patient came in very unstable. Her blood pressure was barely palpable. And so they decided.
Also, this is Judge Kern, aren't there also cases where you can have this without having hypoxia? Although it's a more unusual circumstance?
Right. So there is
response to that. I mean, that you could have this condition without having hypoxia.
The judge ignored that article, which was actually brought out by when the plaintiff's expert was being examined, that there is an article that in 10% of cases of AFE, the patient is not hypoxic. The trial judge simply ignored that. She was more focused on the fact that all of the physicians who testified never had a patient who suffered an AFE and was also hypoxic. But
I think her reasoning was she used the words, it's not a mature issue in the medical community. And I took that to mean that really what she was saying is that it wasn't generally accepted in the medical community. Was that correct?
No. So, right. So the judge.
General acceptance, I'm going to maybe help you a little bit here, because general acceptance doesn't mean that every doctor in the medical community accepts it. That correct?
Right.
Right. Go ahead.
Sorry.
No, go ahead.
It's the methodology.
Right.
The methodology and the medical principle that a doctor can use differential diagnosis methodology to determine whether a patient is experiencing a certain condition, and also the medical principle that's undisputed that a patient can have a condition but not exhibit every single symptom associated with that condition.
Right, and here the plaintiff was exhibiting the other two symptoms of AFE that are commonly known to exist in terms of making a differential diagnosis.
Right, and even though the patient was not exhibiting that third symptom, there was a very rational scientific explanation for why that patient was not hypoxic. It was medically impossible for her to be hypoxic because she was intubated and being ventilated by a machine.
And Dr. Deludi had pointed to peer-reviewed studies which show that you could have this condition without hypoxia, right? But that the jury was not permitted to consider that.
Right, and plaintiff will.
Do any of my colleagues have any further questions? No. Okay, thank you. You have time in response. So.
Thank you.
Appellant Solomon.
Yes, this is Danielle Bennett from Coster, Brady, and Nagler on behalf of Dr. Solomon and his practice. Just quickly addressing Good Samaritan's argument, I would also submit that the court's decision that Good Samaritan was vicariously liable for Dr. Solomon should not be disturbed. Dr. Solomon was the anesthesiologist here, and the facts established that the decedent sought treatment from Good Samaritan via its emergency room, that the decedent was not previously a patient of Dr. Solomon, and that Dr. Solomon only became involved in the decedent's care because he was the on-call anesthesiologist. So based on these factors, the presumption of a parent or of sensible agency set forth in Meduba applies. The only thing that Good Samaritan sets forth to rebut this presumption is the fact that Dr. Solomon wasn't a Good Samaritan employee, which is inconsequential because the presumption under Meduba automatically applies to non-employee providers.
It's a rebuttable presumption, though, correct?
Right, but Good Samaritan doesn't present any rebuttal to the presumption.
It's not enough just that she came in through the emergency room?
It is enough that she just came in through the emergency room in this case because Dr. Solomon.
I'm sorry. Right, I asked it backwards. It's not
right.
It's not, I asked it backwards. It's not enough to create an issue of fact that she was a prior patient of the Dr. Panoff, and that there's at least some indication that her husband tried to contact that office before coming in.
That's with regard to Dr. Panoff. Dr. Solomon, who I represent as the anesthesiologist and had absolutely no previous relationship.
Got it.
And I'd also like to focus on the central issue that Your Honors touched on and that my colleague, Ms. Solomon, touched on, which is that the court erred in precluding evidence that the decedent suffered an amniotic fluid embolism. As you discussed.
Can I ask you a question quickly? If we set aside the verdict on the ground that that the court made an error in terms of its refusal to admit that evidence, do all the findings get set aside? And how does that affect your argument as to the anesthesiologist vis-a-vis Good Samaritan?
Well, at that point, all the findings would get set aside because Good Samaritan is just vicariously liable for.
So without any determination as to that.
Sorry?
Any determination as to that would have to be made anew at a new trial if the court ordered a new trial.
Precisely, because Good Samaritan would be vicariously liable for Dr. Solomon at that point. As you discussed, and as we discussed at length in the trial, there's the 3 symptoms of amniotic fluid embolism, and she inarguably had the first 2 symptoms, but not hypoxia. And here, the court had to ignore endless evidence presented at trial that the decedent could and did suffer an amniotic fluid embolism in the absence of hypoxia. First, the transcript is replete with explanations from both the treating physicians and the defense experts that hypoxia was a medical impossibility, as you touched on, because the decedent was intubated, guaranteeing her oxygenation at the time this occurred. We have no less than 5 physicians who testified to this. In addition, the expert's explanation in addition to the expert's explanation for the lack of hypoxia in this case, the court was also presented with the testimony of the treating physicians that amniotic fluid embolism was the working diagnosis here for the decedent, as well as the testimony of my client's very qualified obstetrical anesthesiology expert that the decedent's death was caused by an amniotic fluid embolism. And most significantly at issue here, which you already touched on, is that the plaintiff's own expert identified medical literature confirming that an amniotic fluid embolism can occur absent hypoxia in 10% of cases. This is a rare occurrence. It's not a novel theory. And a review of the trial transcript basically says, what more did the court need to determine that an amniotic fluid embolism occurring absent hypoxia is not a novel theory and is not junk science? If you look to authoritative authority from your department, it dictates that the trial court abused its discretion not only in precluding the defendant's causation theory, but conducting this quasi-Frye assessment of the theory in the first place. Setting aside the impropriety of the court's procedure in assessing the defendant's causation theory, because I don't have time for that, this quasi-Frye hearing that the trial court conducted regarding this issue was unnecessary and uncalled for, where the defendants did not present a novel theory of causation. As this court has held many times, the Frye test should only be utilized if the basis of the expert's conclusion is novel. I think that one case that's particularly on point here is your court's 2014 decision in Sedec versus Wesley. In that case, the court overturned the trial court's preclusion of the plaintiff's causation theory and rejected the trial court's determination that a Frye hearing was ever necessary. And the court found that this expert's causation theory was, quote, not the type of novel theory of causation that necessitates a Frye hearing, but merely an opinion explaining the physiological process that caused the plaintiff's injuries. And that's applicable here because the defendant's expert opinion that the decedent suffered an AFE absent hypoxia was, again, merely an opinion explaining the physiological process of the decedent's condition along with the impact of being intubated at the same time. This court's discussion regarding medical literature in that case is also important because the court noted that the plaintiff referenced medical literature supporting that their causation theory existed and specifically stated, quote, "At that point, it's up to the jury to decide whether to accept the plaintiff's causation theory as a competent producing cause of the plaintiff's injuries." The additional cases that cited in both our papers, the co-defendant's papers, and the plaintiff's papers make clear that Frye does not require medical experts to find documented support in medical literature that exactly matches their opinions. So in essence, the defendants here did more than necessary to substantiate their causation theory by referencing the support of medical literature directly on point in this case.
Do any of my colleagues have any further questions? Thank you.
Thank you.
Respondent, cross appellant, Hudak.
Yes. Good afternoon, Your Honors. Brian Isaac. I represent the plaintiff in the matter. I'm going to push back a little bit, obviously, on what my adversaries say, but let me try to. I only have 5 minutes. I'm not going to go over my time. Let me talk about the vicarious liability first. As I understand the record, plaintiff was no longer seeing Dr. Panoff. She did treat with that group before, but she was bleeding exceptionally heavy, and she went into that emergency room relying on the emergency room. The trial court was correct in applying the Meduba doctrine here because it was a purely fortuitous circumstance that Dr. Panoff was on call based upon an agreement that she had to be there 24 hours, and there was no reliance at all.
If her husband called Dr. Panoff to be there, would that affect anything? Not at all.
Let me give you the hypothetical. Let's say that I hurt my knee and I had previously treated with an orthopedist, and my wife called that orthopedist and didn't get them. And I raced to the hospital because I had a torn ACL, and that orthopedist partner was there. There's no way that that would create a non-vicarious liability situation because it's a fortuitous circumstance. So that's exactly what happened here. With respect to the AME, I think it's unfair for the defendants to kind of say that the trial court precluded that kind of evidence. The trial court wasn't looking to preclude anything, the way I read the record. And let me just give you some.
Wait a second. Didn't the trial court strike all that testimony?
Absolutely. I didn't say
so
that.
How could you say that that's not precluding the testimony?
I didn't.
What do you call it if someone strikes all the testimony? What other word could you use?
I'm sorry, I didn't say that the trial court didn't strike it. What I said was the trial court wasn't trying to strike it. What the trial court did was it actually struck testimony from my client first, saying there wasn't medical evidence for it. And my adversaries have told you that there's an explanation for this, but I think the explanation, with all due respect, refutes itself. Whether she was non-hypoxic artificially or whether she was non-hypoxic by terms of regular treatment is irrelevant. The record is replete that AME is a diagnosis of exclusion, exactly like RSD. You have to have 3 factors and no other explanation. That's what the medical literature said. That's what the defendant said. Dr. Strobel, whose testimony isn't discussed, let me tell you what he said, and it's not me.
So your argument is that as a matter of law, it was appropriate for the judge to make this decision and not let the jury evaluate all the testimony. That's what you're arguing?
That I am defending the trial court's decision based on the evidence and based on the medical literature that was there. Let me tell you what Dr. Strobel said.
Do you think it would have been an appropriate summary judgment motion if it had been made earlier?
I'm sorry, I didn't hear that, Your Honor.
Do you think it would have been an appropriate summary judgment motion if it had been made earlier, an appropriate pretrial motion to preclude all testimony as to this condition?
You could have made an in limine motion. It wasn't made. But there is no time limit for making an in limine motion. And as you know, Parker against Cornell clearly stands for the proposition that if testimony is not viable, it doesn't go to a jury. The trial court has a gatekeeping function, whether you're applying Daubert or Frye. We apply Frye. And I think what the trial court did here was actually listen to the testimony. And this is the defendant's testimony. This is Alan Strobel. Nobody's mentioned him by name, but I'm going to read to you what he said. 2498 of the record. Quote, no studies that discussed the presentation of AME on a ventilated patient in the absence of hypoxia. Second quote, generally accepted diagnostic criteria include hypotension, she was clearly hypotense, hypoxia, and coagulopathy, wasn't there. 2499, quote, no evidence of hypoxia in this case. Now, he did speak about a summary article. He didn't know the article. He didn't know who the author was. He wasn't sure what the basis of that was. And the fact of the matter is that if you look at the evidence, you can people can point to articles, but that doesn't mean that the case comes in. I can point you to a case directly on point that I just lost in this court, where we cited a ton of articles and it didn't work. It's NAFO, KNAFO. Just going to pull it up in 1 second, against Mount Sinai Hospital, 184 AD3D 478, First Department, 2020.
That was your position. Why didn't you raise it when the doctor's working diagnosis was AFE, when a 3101D was served on you, saying that that was going to be the subject of expert testimony? There's clearly that was not your position prior to the judge raising it at trial.
Well, as you know, Judge Scarpula, a lot of times things that happen pre-trial don't happen during the trial. There are tons of
that's not right. If you knew for 10 years that that was going to be the doctor's position and her view about why her care was proper, and you certainly knew it when the 3101D was served on you, but you never said, your client never raised the issue that the trial judge raised during the course of the trial in that entire period of time. Am I right about that?
That's true, but my
so
point
you
is,
must not have thought prior to the judge raising it that no one thinks this could happen. It was only when the judge raised it that you raised it, correct?
Well, no, the defense would have been, and the plaintiff's defense would have been, and always was, that AME was never an appropriate diagnosis because it was scientifically, medically, and physiologically impossible based upon this record. When the trial court, under its gatekeeping function, said, look, let's find out what the story is, let's take a look at the proof, the evidence developed itself at trial. And the fact of the matter is that, as far as I can see, the trial court's decision was correct based upon the defendant's testimony, based upon the medical evidence that was there, and based upon the exact admissions that I read to you from the defendant's experts. The fact that they asserted a claim doesn't mean that they made a claim, and the fact that they didn't prove a defense that they would have to prove at trial doesn't mean that the trial court was correct in dismissing it. Just like the fact
they couldn't have proved it because the trial judge struck all the testimony and didn't allow any possibility for the doctor to prove that that was a reasonable diagnosis.
Only
right?
after, yeah, only after there was a hearing with full proof and the testimony that I read to you. It wasn't like the trial court made the decision sua sponte. It's not like the trial court didn't give the parties the opportunity to present what their claim was. The trial court did. And
thank you, Mr. Isaac. Do any of my colleagues have any further questions? Thank you. You have time in response, Mr. Isaac. Did Respondent Vinnick?
I'm here, Your Honor. Can you hear me?
Yes.
I'm back. Okay. Just briefly, because I haven't heard anything from the plaintiff appellate regarding Dr. Vinnick, so I'm going to be even briefer, and I think the court will appreciate that. Dr. Vinnick was called in to assist during the cesarean section. There's no dispute that by the time Dr. Vinnick got there, the baby was delivered and the uterus was placed back into the abdomen. So the decision that they argue regarding the hysterectomy is well disputed in our papers. The evidence is clear that it was not his decision. It was the decision by the attending surgeon, Dr. Panoff, and he was just there to assist, and he assisted by closing the fascia and the skin, and that was it. And I'll just refer to the court to disturb the verdict as to Dr. Vinnick. You know, even if the court should order a new trial, it should not be as to Dr. Vinnick. It was a unanimous verdict as to Dr. Vinnick.
So, counsel, is it your position that even if we order a new trial, we could keep a portion of the verdict?
Yes, Dr. Vinnick, there's no dispute that the jury came back with a proper verdict as to Dr. Vinnick, and that looking at the case law, which is the Court of Appeals in Cohen versus Hallmark, that you'd have to find that there was the verdict as to Dr. Vinnick was utterly irrational. You can't find that based upon the trial record. And looking at the Killian versus Parrott case, where you have to find that under any fair interpretation of the evidence, that they could not have rendered a verdict in his favor, which they did. And the last case I'll cite quickly is Pohl versus Our Lady of Mercy Medical Center, decided by this court in 2008, that when the attending makes the decision, which the testimony is that Dr. Panoff made the decision not to do a hysterectomy, Dr. Panoff, as the assistant surgeon who came in after the uterus was placed back in the abdomen, that he's an assisting physician and therefore he cannot be liable. In fact, Dr. Warsoff, the plaintiff's expert, even testified in the record, I believe at page 1998, that the final decision is up to the primary physician, which is exactly the holding in the Pohl case, and that there can only be one surgeon in charge.
Thank you. Any further questions? Thank you. Appellant Good Samaritan has a minute in response.
Thank you, Your Honor. I just want to address the points that were raised in opposition to Good Sam's application. The issue that the patient had previously been transferred from Dr. Panoff's group to Dr. Devine's group is otherwise inconsequential to this matter. The main or the critical issue is what the patient believed when she arrived at the hospital. And here, the record is completely devoid of any evidence as to what the patient believed when she arrived. The second department has held in a long line of cases that when the record is devoid of any showing of what the patient believed as to the physician's relationship with the hospital, that does not support a finding of
we're not hearing you. We don't hear you.
Vicarious. I don't nothing.
Now we do. Go
Okay.
ahead.
When the record is devoid of any indication as to what the patient believed when they presented to the hospital, that cannot support a finding of vicarious liability. Central to the inquiry is what the patient believed when she arrived at the hospital. And there is nothing in this case.
Thank you. Appellant Ramapo.
I'd just like to address plaintiff's argument that AFE is a diagnosis of exclusion. What's missing by plaintiff is that all that information should have been presented to the jury. The jury should have been presented with the two opposing views of what caused this decedent's death, and that did not happen in this case. And it was extremely prejudicial because the defendant attorneys opened explaining to the jury what the evidence would establish. And they told the jury the evidence will establish that the decedent suffered an AFA. And that destroyed the credibility of not only the defendants, but their counsel, which impacted the entire case and impacted even the jury's finding of a departure. So I would argue that the verdict should be set aside, the judgment vacated, and the matter be sent back for a new trial.
Thank you.
Thank you.
Appellant Solomon.
Sorry, unmute. I just wanted to address quickly the plaintiff's discussion regarding the testimony of Dr. Strobel. Yes, Dr. Strobel did testify to the 3 typical symptoms of AFE, and he testified that hypoxia wasn't present here, but at no point did he testify that AFE could not occur absent hypoxia. He, in fact, testified to the opposite, so plaintiff kind of misrepresents his testimony in that regard. He also testified that he performs over 1,300 obstetrical anesthesia procedures in a year, and in his 20 years of practice has only come across 2 AFE cases. So this just goes to show that this is very rare, and AFE absent hypoxia is even more rare because it only occurs in 10% of the AFE cases. So just because Dr. Strobel testified that hypoxia didn't occur here doesn't mean that it cannot occur absent hypoxia. And also the reason that the plaintiff's expert, Dr. DeLuty's testimony regarding AFE was struck was not because it was a novel issue, but because Dr. DeLuty just did not have the qualifications to testify regarding AFE. And with that, I will ask that the verdict be set aside and a new trial ordered. Thank you.
Thank you. Plaintiff Cross Appellant Hudek.
Yes. Judge Kern, you had asked a question that I didn't get a chance to respond to about what happens with the verdicts, and if you find one part is defective and one part isn't. I think the United States Supreme Court in Gasoline Co. against Champlain, and I think this court in Elliott against the City of New York has held that findings by the jury that are not impacted by an adverse decision or an adverse ruling by the court are entitled to be upheld on appeal. As I understand the defendant's defense, they have a defense of causation. So when I thought I understood you to talk about liability findings, they can be retained if you find that they're separately standalone procedures. I would also ask the court, because I don't have a lot of time and I don't want to go over, to look at page 40 of my brief, which was Dr. Solomon's testimony from 1127 to 1130, dealing with the fact that even in a patient whose oxygen is being artificially enhanced, if there was an actual problem with the oxygenation, that would have shown up with some types of tests, including oxygen going down and CO2 going up, which didn't occur in this case. So I think taking that into consideration, the trial court was correct in ruling that there was an insufficient showing that AME, which the attorneys have conceded to you is an extremely rare situation, was proven here sufficient to go to the jury. If there's nothing else, thanks for listening to me.
Thank you. Thank you, Uwal.
Thank you.
Thank you, Your Honors.
Thank you. Thank you, Judge Gish.
Thank you.
So People versus McLaurin, but let's wait until we see that Judge Schulman is back on.
Claims for the first time that it completed the narrative. First problem with that argument is it's not preserved. The government never suggested as much when there was a specific hearsay objection. The government cannot sit back and make no claim of a non-hearsay purpose at trial and then on appeal come forward for the first time and spring a non-hearsay theory onto the defense and to the court. That's a particular problem here because this statement came in for its truth and was used for its truth. Had the government made this argument below, the statement could only have come in with limiting instructions that it not be considered for its truth. Putting the waiver and preservation problem aside, this statement did not complete the narrative. It completed the evidence. This statement was the only evidence of a burglary on September 6, 2012, which is count 1. The government presented no testimony from the complainant. To prove burglary, they had to show that there was a trespass with the purpose of committing a crime inside the dwelling. In this case, the only evidence that there was any such intent was evidence that property was stolen, and that came from the hearsay statement. To know as much, all we have to do is look at the prosecution's statement in summation. The prosecution specifically argued, thus proving how much harm this statement worked to the defense. The best evidence of what somebody's trying to accomplish is what they in fact accomplish. You know what his intent was because he stole from each of those locations. That's how you know that that was his purpose. That is exactly the theory that the government presented below. That is the theory that they could not have made. They could not have advanced that theory if they didn't have this hearsay statement because they had no other evidence of a theft on that date. This statement infected the remaining counts, requiring reversal of those counts too. The standard comes from People versus Morales. If there's a reasonable possibility that the tainted counts infected the remaining counts in a meaningful way, reversal is required of those other counts under the spillover rule. And that is exactly what happened here. There certainly is a reasonable possibility that this statement infected those counts because this case was presented to the jury as a pattern burglary. So what the prosecution was able to do was say, you can see the pattern happening over and over again. To move to the count 2 is the same exact location. They have no solid evidence of a burglary on that date. So the way they can prove a burglary of count 2, because it's in the same location as count 1, the one that was infected by the hearsay, is to say, aha, see, pattern, same location. The same thing happens with counts 3 and 4. In those counts, there's a laptop stolen. The government is able to persuasively argue in summation. You see, he stole a laptop in count 1. He did it again in count 3 and 4. Perhaps we can't show an ironclad, no question about it, that the jury would have acquitted if this hadn't come in. But that's not what we have to show. We need only show a reasonable possibility that this tainted the verdict. And the government cannot meet its burden of proving otherwise in this case.
Any questions from my colleagues?
No.
Thank you. Thank you, Counselor. The People.
May it please the court, Patricia Kern for the People. Your Honors, the court's evidentiary ruling was correct here. I remind Your Honors that in this particular instance, the officer was asked if he received a radio call for an incident occurring at the West 71st Street location. He said yes, and when asked to describe for the jurors what the call was, he answered, my partner and I, we received a 911 call. Defense counsel said, objection, hearsay, and the court overruled it. The officer then said, we received a call from the NYPD dispatcher of a stolen property, a laptop taken at that location, which is 220 West 71st Street. Now, in this instance on appeal, the defense has only partially preserved his current claim. He is now arguing that this particular answer by the officer about the stolen property should have been stricken because it was grounds to show critical evidence of intent to commit a crime here. However, he never argued that below. He only said hearsay. He never followed up. The People had no reason to explain that this completed the narrative or was evidence of the officer's state of mind because the court overruled the objection. Given that, the defendant has not preserved his specific claim on appeal. In any event, as argued in our brief, there was sufficient evidence here that this radio call was not submitted for its truth, but to explain the officer's state of mind and to complete the narrative and show background evidence. Without it, the jurors would not have known why the officer went to the particular location or why he did what he did. In any event, even if this court decides that the court below erred in allowing the evidence, any such error would be harmless. The jury did not, if the jury had not heard this information, they would not have acquitted this defendant of the burglary. There was sufficient evidence that this defendant intended to commit a crime here.
As you know from the evidence, the superintendent was watching on the monitor in real time when the defendant entered the lobby of the 71st Street building. And then when the defendant went up in the elevator, he came down approximately 10 minutes later, and he was dragging a suitcase behind him. It is unfortunate that Mr. Woolen was unable to testify at trial, but the detective testified that he went and talked to Mr. Woolen 2 days after this and found that the luggage in Mr. Woolen's apartment matched the luggage that the defendant had taken out and was shown to have in possession on the video. This and the other evidence of the officers responding to Mr. Woolen's apartment, finding that there was a door from his apartment leading to the roof, and the detective's testimony about finding out what time he was gone from his apartment, and that's why they focused on that time period to establish the time frame for the.
Before Judge Friedman, before your time is up, I want to turn your attention to something else. I mean, there is a Miranda issue here. So before Detectives Del Pozo and DeLillo questioned after Miranda warnings, questioned the defendant, he was questioned by Detectives Stanley and Hennessy. Is that correct? Is there any indication in the record that those detectives gave the defendant Miranda warnings?
Yes, Your Honor. As the court found below, the evidence showed that based on Del Pozo's testimony, when he arrived at the precinct, he spoke to the other detectives, Hennessy and Stanley, who were from different precincts. They told him that they had spoken to the defendant. He also testified that there was.
Well, that doesn't mean that they spoke to him, doesn't mean that they gave him Miranda warnings.
This is true, but they also told him that it was okay for Del Pozo to speak to him and that the defendant had not asked for a lawyer. Del Pozo also testified that it was police procedure for detectives to tell other detectives if the defendant had asked for a lawyer. And Del Pozo also testified that the detectives who had taken statements from this defendant previously had Miranda sheets in their hands. Given all this testimony, the court correctly found that the defendant had received his Miranda warnings prior to Del Pozo's talking to him. And I should remind the court as well.
You're saying there was an actual finding by the trial judge about prior Miranda warnings?
Just a moment, Your Honor. The court found, I did find Del Pozo to be credible. He did not insist, for example, that he was there when he was advised by his rights by the prior detectives.
That's what you're saying is the finding?
Yes, he did indicate that he understood the fact that the other detectives told him that the defendant had not requested counsel and had been willing to speak, that the defendant had in fact been advised of his rights. I think that's a sufficient finding to indicate that the court found that the prior detectives had read him his rights. And then he goes on to find that Biondello in Del Pozo's presence also read him his rights.
Any further questions? Thank you.
Thank you.
Mr. Boba.
Your Honor, since 1966, there's been a very simple and clear way to prove Miranda warnings. You bring in the officer and you have the officer testify under oath that they administered the warnings. This argument that the possession of a Miranda sheet proves the administration.
You didn't argue, you didn't make the point below that he wasn't Mirandized by those officers.
The prosecution specifically acknowledged that they had problems with that theory and in the oral argument to the court, and then made an attenuation argument. The court then said, and the portion that we're talking about is on page 68 of the suppression hearing transcripts, there really is not a finding. The court just says that the officer understood that because the other detectives had told him that the defendant had not requested counsel and had been willing to speak, that he had been advised of his rights.
Wait, you were saying that the attorney for your client made a motion to or asked that the statements be suppressed on the grounds that the previous police officers hadn't Mirandized him?
No, what happened?
You did not raise that issue below at all.
But Your Honor, but under 470.052, That's not the only way to preserve a claim. When the court reaches the issue, when the court confronts and decides the issue, that preserves the claim under 470.052. That's exactly what happened in this case. That is precisely what happened. The prosecutor raises the argument, and it's their burden to do so, and the court says, well, even if there was this possibility of Miranda warnings being administered, in any event, before the defendant was questioned about the incident, he was Mirandized.
It's the prosecutor's burden to raise that the Miranda warnings weren't given previously?
The prosecution's burden is to prove the administration of Miranda warnings and attenuation. So what the government is doing here is simply following that rule. The government raises the argument because they realize they have a problem. The court then confronts it and decides it. And a good example of this is People versus Rios, a case from this court in 2016.
Thank you, Mr. Weber. Any further questions for counsel? Thank you. Thank you both.
Thank you.
Plotch versus 435 East 85th.
Good afternoon, Your Honors. Adam Plotch, I'm the appellant pro se. Thank you for this opportunity. It's the first time that I have ever argued a case pro se before this court. Your Honors, the respondent co-op has in its governing document, specifically the proprietary lease, a familiar provision that provides that in the event of a non-judicial foreclosure sale by a secured lender, approval of the purchaser will not be unreasonably withheld or delayed. In fact, the co-op, the board, relinquishes its typical control over these transactions and vests its management.
This is Judge Kern. What about the long line of cases which you acknowledge that someone in your position does not have standing to make this type of argument? Why should we deviate from well-established case law, which we've held on numerous occasions?
Let me preface my answer by saying that this is a bit of a convoluted appeal in the sense that as far as my causes of action against the bank are concerned, I agree with you, Your Honor, the longstanding authority of this court should control, and you should not deviate from it. As for my causes of action against the co-op, I submit that this longstanding authority perhaps should be reconsidered. These are mutually exclusive, irreconcilable, inconsistent causes of action, but which I submit under CPLR 3014, I have the right to assert at the pleading stage, which is where this case was dismissed. I'm happy to address either one, the causes of action against the bank or the co-op first, whichever Your Honor prefers.
Whatever you want to do.
All right. With respect to the bank, assuming that the longstanding jurisprudence of this court controls, and I do not have standing to enforce the provisions of the lease as against the co-op, the bank, according to another line of cases, does indeed have such standing. That's the Bankers Trust versus West Shore case. The bank can sue the co-op and can compel them to abide by the provision of the lease that they violated. What makes this case unique, I believe it's an issue of first impression, I don't think that it existed in any of the prior cases on this point, is that the contract between the bank and myself, the terms of sale, explicitly provides that this favorable provision in the co-op's proprietary lease will govern this transaction. In other words, there is a promise by the bank, who is the unilateral author of the contract. This was not mutually negotiated. They drafted it themselves. And in the contract that they drafted and that they signed, they promised that a specific rule in the co-op's proprietary lease will govern. Now, again, under the longstanding jurisprudence of the court, I don't have the right to compel the co-op to abide by this rule, but the bank does. And so if the bank puts in its contract with me a promise that a third party who is essentially under their control, for lack of a better term, in the sense that they have the ability to compel them to act, if they make a promise that that third party is going to act in a certain way and I don't have the power myself to compel that third party to act that way, that must be perceived as an implicit promise that they will, in fact, compel the co-op to act that way. If I could give a possible analogy, Justice Kern, if I were to enter into a contract with Your Honor that I draft, in which there's a provision that says, I promise that my personal doctor, Dr. Smith, will release my medical records to you. Dr. Smith is not a party to this contract, but I promise that he will do that. And then we enter into the contract, Dr. Smith does not release my medical records to you. What is your recourse? You can't sue Dr. Smith. He's not a party to the contract. He never made a promise to you. But I have the power as the patient to compel my doctor to release my medical records to you. And so if I entered into a contract with you where I promised that a third party who is under my control, for lack of a better term, will do a certain thing, I would think that Your Honor would have to have a cause of action against me for breach of contract, for promising that that third party under my control will act in a certain way when he didn't. Otherwise, it's a meaningless provision in the contract. It's nothing more than an optimistic hope. And I would point out also, Justice
Scarpelli, I don't understand what you're saying. You were put up for the board. What's the breach? They did exactly what they told you they would do. They put you up to the board and the board rejected you.
No, that's what the provision says. What the provision says in the proprietary lease, the one that I don't have standing to enforce on my own, is that it will not be subject to board approval. The board relinquishes its control and power. And instead, that's what it says in paragraph 17.
No, that's not what it says.
I have it right in front of me.
I don't think, no one thinks that it says that. I don't think anyone thinks that it says that.
The provision, which I can read right here, it will be subject only to the approval of the then managing agent of the lessor, which approval shall not be unreasonably withheld.
So they put it to the managing agent goes to the board says no, the managing agent says no. They've complied 100% with the contract.
Actually, here the managing agent said yes, and afterwards,
right?
And then changed its mind.
Yes, but it's subject to a reasonableness standard. It can't be done arbitrarily. And if it's a reasonableness standard, then it's not something
that be reasonable that they wanted to avoid this litigation with you, which they're now involved in? Wouldn't that be a reasonable reason?
Under Real Property Law 227F, it's not reasonable. You're not allowed to not give somebody a lease because of his history of litigation. And by the way, that's a bogus answer. I've been buying co-ops every day for the past 17 years. I have never sued a co-op, maybe once in all of those years, and literally 1,000 transactions. It was my fights were typically with banks and mortgages and statutes of limitations on mortgages, not with co-ops. This is not an area where I fight. So it was
Mr. Platt, you're past your allotted time, so thank you. Any of my colleagues have any further questions?
Your Honor, I haven't addressed any of the points against the co-op.
Well, we have your brief, so, and we don't have any further questions, so we're going to turn to the respondents. Defendant 435.
Good afternoon, Your Honors. May it please the court, Tracy Peterson of Braverman Greenspun for the co-op respondents. The standard of appellate review is whether the lower court abused its discretion. Here, the appellant doesn't contend that the lower court abused its discretion. In fact, appellant readily concedes that the lower court followed long-standing accepted precedent addressed to basic contract law. By this appeal, the appellant is asking the court to reverse that long-standing accepted precedent. He's not only asking this court to reverse it, but he is asking this court to hold newly that strangers to a contract, that a contract vendee is in fact a third-party beneficiary. And can enforce terms of a contract. The appellant has not offered any compelling argument for this court to upend this long-standing precedent. Moreover, the appellant did not preserve this argument for appeal. Although the co-op respondents made these arguments to the lower court, the appellant opted not to argue to the lower court that it should ignore this long-standing precedent and create new law.
Any further questions for counsel? Thank you.
Thank you.
J.P. Morgan.
Good afternoon, Your Honors. May it please the court, Brian Scabetta from McCalla Raymer Pierce on behalf of respondent J.P. Morgan Chase Bank N.A. As I listened to Mr. Plotch and as I read his brief, he keeps talking about a guarantee and a promise that Chase made in the terms of sale. But when I actually look at the terms of sale, that's just not what they say. It says that the purchase of the collateral, the shares, is subject to this provision of the proprietary lease that we've discussed already. And the purchaser acknowledges that it is his or her responsibility to comply with all the requirements of the said proprietary lease, including that specific provision. And then the purchaser says they review and agree to comply with same. And the purpose of that provision is to put them on alert that they have to get the approval of the managing agent. That is the purpose of that provision. There's no express promise that Chase would take action on their behalf in the event that the managing agent, within its discretion, elected to decline Mr. Plotch as a purchaser. So he's asking that the court read language into the agreement that, in our view, is not there. And unless your honors have anything further for me, I don't have anything else.
Thank you.
Thank you all.
Thank you all. Shane versus Tricon Construction.
Good afternoon, Your Honor. This is Jonathan Glasser of Lester Schwab, representing CP Plaza and Tricon Construction. May it please the court. The labor law should be construed with a common sense approach to the realities of the workplace. Not every construction site accident involving the forces of gravity from a scaffold triggers absolute liability under the labor law. For example, a plaintiff's total loss of consciousness as a result of a pre-existing condition is not an expected risk of work at a construction site.
Yeah, but what is, this is Judge Shulman. What is the basis of your claim that his medical condition or it was the trigger of this loss of consciousness, as opposed to the possibility that he may have touched a live wire in attempting to remove the light fixture on the Baker scaffold? I mean, there's absolutely nothing on this record that would even support that theory, and the fact that your engineer expert seems to suggest that, although he's not a medical expert. I see nothing on this record, sir. So where's the support for that?
Thank you, Your Honor. Just as an initial matter, there is absolutely zero evidence in the record that he suffered an electrical shock. Mere speculation after the fact. He was not treated for an electrical shock by any physician. He himself doesn't claim that he was shocked, although after the accident, there is some discussion that he had with the doctor about a shock. But the only testimony that there is in the record is that the power to that circuit was turned off by the electrician prior to the work that was done at the site. On the other hand, there is
Judge Kern. Let's even assume, for sake of argument, that he had a pre-existing medical condition, even though there doesn't seem to be much evidence of that in the record. Isn't there well-established case law in the First Department which would show that even if he had a pre-existing medical condition, that is not the sole proximate cause, because if there had been side rails, the accident would not have otherwise happened, as a result of which it's a classic 240 labor case?
Thank you, Your Honor. We're not actually arguing sole proximate cause specifically. What we're arguing is that plaintiff has a burden to make out a 240 case. And the only piece of that burden...
This is Judge Friedman. He doesn't make that burden out by showing that there weren't side rails on this scaffold and he fell off of it?
Not when there's an unconscious plaintiff, Your Honor. In cases where there's an unconscious plaintiff, such as this court's ruling in Mumford, the courts generally find a question of fact about whether or not there is proximate causation and send it back for a jury. And in this particular
conscious
case,
or unconscious, would he have fallen if there were side rails?
That is an excellent question, Your Honor. We think that's the very question that the jury should decide. Without side rails,
but in a 241 context, doesn't that question augur against you?
I don't understand it.
If there was supposed to be side rails and he falls off, whether he was conscious or unconscious, doesn't that make you liable under 241?
Not unless there's a showing of proximate causation. When there's a complete loss of consciousness of a plaintiff on a scaffold, the plaintiff is unable to hold on to a railing, to grab it. There's no proof that the height of the railing compared to the height of the plaintiff wouldn't have resulted in him flopping over any railing that was allegedly missing. So we believe that there are questions of fact, and the First Department and the Second Department in analogous cases have held that where there's a completely unconscious plaintiff, the question of proximate causation must go to the jury. The plaintiff isn't there to explain, is unable to explain.
How are you distinguishing our First Department case, I can't pronounce it, of Lajqui, Lajqui, Why isn't that case dispositive?
That's a great question, Your Honor. It was hard for us to figure that out ourselves. The case doesn't say very much. Just recently, yesterday, in fact, I was able to put my hands on a copy of the appellant's briefing in that case. If the court permits, I would like to tell you a little bit about the facts of that case that I learned from the briefing. May I continue?
Go ahead.
According to the appellant's briefing, Mr. Lodgkey was not unconscious before he fell. He only became unconscious upon falling and striking the bottom of a pit that he was working in. Another important fact in that case is that Lodgkey was not provided any safety device at all. He was simply, he had no scaffold, no ladder. He was resting one foot on the bucket of a front loader and the other foot on a boulder as he was using a jackhammer to break up that boulder that he was resting his foot on. The dust from the boulder clogged his mask, causing him to become dizzy, and he fell. And he became unconscious upon it when he hit the ground. So the absence of any safety device at all, as opposed to here where we do have a scaffold, makes Lodgkey a very different case, Your Honor.
Any further questions? Thank you, Counselor. Boyle?
Good afternoon. Sarah David for defendant, third-party plaintiff, respondent Michael Boyle. Without belaboring the points made by my colleague, Mr. Glasser, I join in the arguments set forth by the appellant in this matter. The decision on appeal erroneously found that plaintiff experienced an electric shock causing him to fall from the scaffold, when in fact there is no evidence of such a shock. Rather, the testimony and evidence elicited shows that plaintiff fainted due to a pre-existing medical condition about which he was aware and which caused him to faint on job sites in the past. Responsive to the question a moment ago as to where that exists in the record, I would direct you to the testimony of the plaintiff's stepson, another worker on the site who testified that plaintiff had a history of fainting on job sites in the past due to a pre-existing medical condition that he didn't tell any of his employers about.
This is Judge Scarpula. Are you saying that the fact that a few weeks at another job a couple months ago he had an infection, a viral infection, and he got some medication and he was dizzy and passed out because of the viral infection, that's your evidence of a pre-existing condition with that makes him pass out on job sites? That's what you're talking about?
There were indications by his family member that this was a pre-existing and known condition.
I'm asking you specifically, counsel, is that what you're referring to? The son saying he had a virus and he was dehydrated and he passed out and then he got his medication for it. Is that the testimony that you are talking about to say that he had a pre-existing condition?
That is testimony of a pre-existing condition, and it is more evidence than the evidence plaintiff relies on to say that there was an electric shock, which is purely speculative on the plaintiff's part, as there is simply no evidence of it. He was not treated for receiving a shock after the accident.
Thank you. Any other questions? Thank you. Mr. Goldblatt for plaintiff.
Thank you, Your Honor. May it please the court. Judge, many of the questions that the bench has raised with appellants are the same questions that I raised in my brief, and I don't want to rehash them. What I do want to clarify, though, is there was no testimony from this son-in-law that he had a pre-existing condition. Mr. Badillo was, in fact, deposed, and he denied ever saying that. The only evidence in the record is hearsay statements made by employees of the defendants that after the incident, Mr. Badillo told me that blah, blah, blah. That is the only evidence that is in the record, and that's not sufficient. It's hearsay. The appellants also rely upon, and this is what I think Justice Scarpula was getting at. There was a vocational exam done by the defense, Dr. Regals, who is reading a medical record that is not in the record, but nonetheless, the plaintiff had a severe respiratory infection for 3 weeks. And that is the only incident where he was noted to have fainted. All of his colleagues who worked with him for 8 months all said, we never saw him have a problem working. We never saw him faint or pass out. We never saw any physical limitations, preventing him from doing any kind of work. So the appellant's entire argument seems to be premised on their conclusion that my client passed out and fell. Now, again, even if that happened, I don't think it's relevant. But the fact is, there was no medical opinion that happened. There was no witness who says that is what happened. There was no one who has concluded that is what happened. The reason my client doesn't remember what happened is because he landed on his head, fractured his skull, and had a severe brain injury, which is very common with people who have brain injury and have no recollection of what caused them to fall. Whether he was shocked, whether he simply lost his balance while raising his hands above his head, removing lighting, or whatever the reason, it is not disputed. There were no side rails, and that's a statutory violation, despite what their expert says, because there's a case and that this court has cited that it doesn't matter what an expert says. First of all, his expert opinion is not based upon any facts in the record, but the expert opinion is irrelevant if it's contrary to the law. So unless there are any further questions from the court, I would thank you for your attention and rely upon my submissions.
Thank you. Dollar Tree?
May it please the court, my name is Shannon Sachs, and I'm here on behalf of Dollar Tree. Although I didn't submit papers, I do want to point out to the court that there was eyewitness testimony by Mr. Zink, his coworker, who did say that his eyes were closed. Mr. Deschain's eyes were closed as he saw him fall off the scaffold. He didn't attempt to grab a railing or anything. He just fell rigid to the ground. I think that's evidence that he was unconscious, and I'm not saying that he was predisposed for anything, but at the time of the incident, I think there's a question of fact of whether or not the scaffold, regardless if there was a rail, if it would have held him or otherwise. And that's
thank you. Thank you. Thank you all.
All right. Have a nice day.
Thank you. You too.
Thank you, Your Honor.
ECD New York Inc. versus 616 First Avenue.
May it please the court, Your Honor. Good afternoon. My name is Ira Schulman from the Shepard Mullen firm. The order of the IAS court, which denied the lender's motion to dismiss the causes of action for trust fund diversion, should be reversed. In this case, the lenders provided funding pursuant to a building loan agreement, which was secured by an assignment of leases and rents. These documents were filed with the county clerk appropriately. The lenders only provided, but did not receive any funds in connection with this project. The plaintiff nonetheless brought causes of action against the lenders for diversion of trust funds and assets under Article 3A of the lien law. You can't be a trustee of funds unless you're receiving funds. And this was always a downstream transaction. The lender was paying down to the owner for distribution.
Could you break out your arguments as between the two different provisions? Because one of the claims is under 79 and one is under 77, and they have different standards and different arguments.
Well, the Article 77 and 79, well, either claim, Your Honors, rely on the function of being a trustee.
Is that correct, though? Is that true about 77? That you have to be a trustee? Can't you be a transferee under 77?
Well, you can be a transferee under 77, but they were never were a transferee.
What?
They never were a transferee. Article 77 says a trust arising under this article may be enforced by the holder of any trust claim. And in order to hold a trust claim, it's got to be asserted against someone who's a trustee or someone who received trust funds improperly. And in this case, there is simply no facts that we're aware of which demonstrates that the lenders ever received trust funds. In fact, the only trust fund claim that the respondents make that the lenders supposedly received were based on the assignment of rents. But it's very, very clear, Your Honors, that the assignment of rents is not a trust asset, because a trust asset is not specified in Lien Law Section 70 as what a trust asset comprises of. There are many other things. There are proceeds of loans and the like, but not assignments of rents. In fact, assignment of rents is specified in Lien Law Section 70, subparagraph 5E, but it is the advances secured by the assignment of rents, not the rents themselves, that are trust assets. There were no advances from the owner to the lender here. There was never any upstream money that was coming back to the lender. This was always a conventional construction loan situation, and the respondents are seeking to turn it into a situation, I guess, somewhat akin in their argument to the Aspro case, but the facts in Aspro are so plainly distinguishable to what the court has. And when the IAS court made its decision, it simply said Aspro. Well, in Aspro, it was the contractor, not the owner, who took out the loan. As security for that loan, the contractor assigned all its right, title, and interest in the construction contract to the lender. And the owner agreed to make payments directly to the lender to repay the balance of the contractor's loan. Well, that's clearly a lien law issue. The lender had an assignment of the contractor or the owner of the owner's construction contracts. There was no lender trustee situation. They were the owner trustee by assignment. The lien law specifies various entities that can be trustees. It can be an owner, it can be an owner trust, an owner trustee, a contractor trust, and a subcontractor trust. There's no lender trust. The New York law is clear that lenders are not trustees, because who in their right mind is a lender would want to lend money to a borrower on a construction project in New York City and somehow take on the statutory obligations of a lien law trustee?
So
that would be...
Judge Scarpullo, are you saying the difference is that here you only hold the rents as collateral, as opposed to you don't have a right to the rent stream as... Is that the distinction you're making?
Exactly. The rents are security. They're not proceeds. And in this case, where the lender is simply acting in the most conventional way we know how to do a building loan agreement, how can there be trustee obligation imposed on them? Now,
so, counsel, assuming you're not a trustee, assuming you've made out Aspro's distinguishable, you're not a trustee, you would also have the burden of showing there's been no transfers made to dismiss both causes of action. And have you and how have you met that burden of showing that as a matter of law, there were no transfers made to you under the lien law?
Well, there were no transfers. Well, we meet the burden by, first of all, showing the terms and conditions of the building loan agreement, which don't provide for transfers. There are no trust funds that are going back from the borrower, the borrower to the lender. And in fact, that's not even alleged in the amended complaint, because it never happened. There's nothing in the record to even suggest that funds were going back to the lender. The only funds they rest on, again, is this concept of assignment of rents. But as I've said before, the assignment of rents themselves are not lien law trust funds. And I just want to turn to two other issues here. One is the respondents claim that because the trustees did not respond to the demand for a verified statement under Article 3A of the lien law, that somehow that turns them into trustees. Well, that obviously begs the question whether they were trustees to begin with. If you're not a lien law trustee, then you have no obligation to respond to a verified statement. And the verified statement demand may only be made by statute by a beneficiary of the trust. And there was no trust to be a beneficiary of. And I would also note...
Thank you. You have time in response.
Thank you.
Let's hear from the respondent.
Thank you, Your Honors. This is Benjamin Ratner on behalf of Plaintiff Respondent ECD New York with the law firm Tremelli & Wood. We're here, as Your Honors know, on a motion on review of a motion to dismiss only on documentary evidence. It's a 3211A1 motion only, and that documentary evidence that the defendants are relying on is a notice of lending. The complaint, and so the question here is, does that notice of lending conclusively establish a defense as a matter of law? And the answer is no. And the reason the answer is no is because of the allegations in the complaint and the failure of the AIG defendants to respond to a demand for a verified statement under Lien Law Section 73. In our complaint, in the amended complaint, we allege that a separate group of defendants here, called that I'll refer to as the JDS defendants, the owner and general contractor and their principal, diverted trust fund assets. And in addition to that, that these trust fund assets were transferred to AIG. And you can see that in the complaint at paragraphs 47 and 48, I believe it is, which is page 49 of the record.
Counsel, this is Judge Scarpula. What is the basis of that allegation? I mean, I could say the sky is purple every day of the week, but you have to have some facts to back it up in the face of a document that shows something completely different. So just tell me, what facts in the complaint are you basing that conclusion that money was transferred? That the bank, the lender took trust fund monies.
We believe, based on the failure to pay and based on Mr. Stern and his entity's conduct, and in fact, discovery in this matter has revealed several instances of diversion by Mr. Stern and his entity.
Oh, no, you're talking about the bank now. You're saying the bank has trust fund money. What is the basis of that allegation? What facts do you allege to base that allegation on?
We believe that the failure to pay us, that JDS diverted money, and we believe that it was repaid. It repaid the loan with at least some trust fund assets.
Based on what? Again, I can say every day of the week the sky is purple. What facts lead you to that belief, that reasonable belief?
We believe, for one thing, that the assignment of leases and rents and other receipts that were payable over the course of the
which statutory provision, which statutory section talks about leases of rents from leases?
Well, let me reframe that. There's no statutory provision about assignment of leases and rents per se, other than what Mr. Schulman mentioned that I'm aware of. But what's relevant here is Section 73 of the Lien Law, which provides lenders the ability to present a defense based on a notice of lending. It prevents them from having a trust fund diversion claim brought against them. However,
but it doesn't help you for the period before that notice of lending. And the notice of lending takes place in January, but there was a transaction in December. So you're certainly not covered for that December to January period by the notice of lending.
That is absolutely correct, Your Honor. The notice of lending, if it was timely filed, may have provided a defense. But Section 73, Subdivision 4 of the Lien Law expressly states that if a trust fund beneficiary demands a verified statement and it's served by registered or certified mail on the transferee, here that would be the AIG defendants, and it is not responded to properly, the person or entity that filed that notice of lending loses the affirmative defense provided by the notice of lending. It's very clear under the statute, and that's what we have here. And that's why, one of the reasons why, this notice of lending.
Yeah, which statutory language are you pointing to for that?
It's Lien Law Section 73, Subdivision 4. The failure to respond to a demand for a verified statement served upon a transferee or a trustee negates the availability of a defense founded upon a notice of lending.
But that assumes, this is Judge Scarpula, that assumes that the bank is a trustee, right? And that's the thing, you have to get to that first.
Well,
right?
It can be a trustee or it can be a transferee. Either one. In fact, Section 73 of the lien law is titled "Affirmative Defense and Action against transferee of trust assets, or to charge trustee in certain cases notice of lending." So it contemplates both a situation where you've got a trustee, or you've got a situation where you've got a transferee, and we allege that is the case here in the complaint. And so, as Justice Friedman correctly noted, the lien law section 73 subdivision 3B actually also shows that this notice of lending isn't available, at least for one of the transfers made under the building loan agreement, because section 73 subdivision 3B requires it only permits the defense for funds advanced on the date of the notice of lending, after the notice of lending was filed, or within 5 days before the notice of lending was filed. Here we have the building loan agreement and funds advanced on December 22nd, 2016. The notice of lending was not filed and recorded in the county clerk's office until January 27th, 2017. And it's undisputed that funds were advanced in the interim. And
so
therefore,
that gets you to support the third cause of action.
And the fourth, because in either case, you've got diversion of trust. Both.
Except that rents are not provided. The statute doesn't refer to rents.
Well, but we're not saying that rents are necessarily the only thing that could have been transferred. And this goes back to my point about the merits discovery that we've received. It's what we've seen is actual diversion. And unfortunately, discovery regarding AIG was stayed by this court earlier this year. And so we haven't been able to get responses to our discovery requests, which would illuminate whether or not they received trust assets. But we're not at the merit stage, we're at the pleading stage. And it's their burden to conclusively demonstrate that this notice of lending precludes us from maintaining suit, and they cannot do that. So that is essentially the basis of why this motion to dismiss was correctly decided and correctly denied by the trial court.
Thank you. Any further questions? You have 3 minutes.
Yes, thank you, Your Honor. I'm sorry, but Respondents' Counsel just simply couldn't come up with a reason to claim why the lenders or lien law trustees are transferees here. It's clear they're not. It's clear that what the respondents are trying to do are drag the lenders into a lawsuit, have them cause mischief with their borrower, and maybe work out a deal. But that's not what happens here. They are looking to change the law to where you're going to have lenders walk away from projects in New York.
Why is he wrong about the fourth cause of action, that there's this period, rather the third cause of action, because there's this period between December and January, which predates the notice of lending? Where is his analysis wrong about that?
Because the affirmative defense states in any action against a person to whom trust assets have been transferred. That's the fundamental basis of the notice of lending provision, and there's nothing in the record to support that.
And it covers periods before its service?
Yes, there's nothing in the record to justify that. This is simply speculation by a plaintiff who's looking to hold lenders in for whatever use they can make of it.
But
This would be
Counsel, this is Judge Scarpullo, but the allegation is made, correct, in the complaint?
the allegation is made, but there has to be something more than an allegation. All you've heard from the respondent are aspersions against the principle of the borrower. He did this, he did that. There's nothing that the lenders did. All the lenders did is what lenders always do, is lend money. They lent money secured by an assignment of rents, which is not a lien or trust. These lenders should never be in this action to begin with. Aspro is totally distinguishable on the facts, and the court should let the lenders out, grant the motion, and let this litigation proceed as it should be, which is a breach of contract claim between a subcontractor and a lender, and it's subject to the subcontractor and the general contractor. That's all this case ever was, and that's all this case ever should be. Thank you for your time, Your Honor.
Thank you both. Thank you both. I see Judge Renwick has joined us. Judge Renwick?
I understand you still have other cases, so I will wait.
You know, since you're here, if both sides are here, we can call the case now. Let me just, because I had told them it was going to be later, but TCR Sports, are appellant and respondent present?
Respondent is present, Your Honor.
Is the appellant present? Is the appellant on TCR Sports present?
He is, Your Honor.
Okay, but we don't hear him.
I think he's on mute.
Could you unmute your microphone? Counselor on TCR, appellant on TCR Sports?
Is that he who's at the microphone?
I think so. Your microphone is muted. We don't hear you.
Maybe we should give him a few minutes to figure it out and you call another case. I'll just.
I don't even see him speaking though.
Yeah, I don't.
He's speaking.
He's speaking?
He's speaking,
Okay.
yes.
Okay, he's speaking.
You can't unmute.
You can't unmute, okay.
It looks like he might be calling for help.
Okay.
Is that Mr. Schiller?
Oh, this is Mr. Phillips. Can you hear me now?
Yeah, now we can. Okay, we're going to take the case now. Judge Renwick is going to, I'm recused, so Judge Renwick is going to come in. I'm going to step away, and you can proceed in a moment.
Okay, Mr. Schiller, I believe that Justice Friedman is off now. Okay, so why don't you note your appearance and begin?
Will Justice Renwick. Carter Phillips, actually representing the Baltimore Orioles, is the petitioner in this case. Good afternoon, and may it please the court. Justice Acosta wrote the last
Counsel,
time this case was.
can I just get right to it and ask you a question, please? As I'm sure you're well aware, judicial review by us of arbitrators' rulings is very limited. And what? Can you hear me?
Yes, Your Honor.
Can you hear me?
He said yes.
Yes, Your Honor. Yes.
I think Justice Renwick is having a problem.
Yeah.
Okay, let me ask a question since she's not able to finish her question right at the moment. She seems frozen. I think she was saying that our review is extremely, extremely limited. This case is not the last case. The last case, there was a clear conflict found by the court in terms of the representation by Proskauer, which is not present in this case. So why shouldn't we just affirm in this case as opposed to that case, since we already clearly held in the majority in the last decision that it was appropriate for this tribunal to decide the case. And although you were speaking about Judge Acosta, he was a dissent. He wasn't the majority in that case. So that issue's already been decided. So why shouldn't we affirm now?
Yeah, that issue was decided on the standards of what this court decides with respect to the question of whether or not the RSDC and Major League Baseball should recuse themselves. This court did not purport to decide whether the RSDC, as a matter of its own decision-making authority, should decide that there is, in fact, a hopelessly conflicted situation between the RSDC, MLB, and the proper and impartial disposition of this particular case.
There's no question that our decision held in the last case that the RSDC was an appropriate forum and that they could go ahead and decide this arbitration.
Right, and the plurality opinion specifically identified the guaranteed repayment that my friend on the other side specifically, and for the first time at oral argument, said would take the $25 million problem off the table. And what happened? Did he in fact post a bond? Did the Nationals in fact pay the $25 million and take that issue off the table? No. What they did was they entered into an agreement with Major League Baseball that said, if Major League Baseball commences a hearing, if the RSDC commences a hearing, then we will pay back the $25 million. What I submit to you is that is a fundamentally different problem now, because they've taken the $25 million to essentially pay MLB and RSDC not to recuse themselves, which they had an independent duty to evaluate as whether they should recuse themselves. And the $25 million deal, right, the secret deal they made, took that issue off the table. We didn't get an independent assessment of that. And that by itself demonstrates what we've already seen, which is that this is a very, very polluted pool, swimming pool, which was Judge Acosta's metaphor at the oral argument the last time. And it has gotten nothing but more polluted as a consequence of the interaction between Major League Baseball and the RSDC in this particular case.
Counsel, I'm not following your argument that the repayment of the loan is evidence of partiality. If anything, it would seem to me that it's evidence that any possible partiality has been removed, the opposite of what you're saying.
All that it took off the table was how the ultimate RSDC was going to decide the issue, in the sense of it didn't, the $25 million was no longer dependent on them ruling in favor of the Nationals the way it had been set up previously. That, I think on that score, I don't think any court could possibly conclude that that original arrangement is anything other than evident partiality. What they took off the table, though, by virtue of what we lost through that we were entitled to, was an impartial assessment of whether or not recusal was warranted under the circumstances. Every arbitrator has an independent duty to evaluate whether or not that arbitrator can be fair and partial under the circumstances. And not only did they have 25 million reasons not to say, you know what, the better answer here is to go to the AAA, but they also refused to answer our specific requests for the relationship between MLB and the RSDC. We asked them and we said, what has the MLB told you about this case so that we can be confident that you can evaluate it independently from Major League Baseball under these circumstances? And we were denied the right to have any of those statements, any of that evidence made available to us. And I submit to you that—
Judge Scarpula, isn't that the same thing that happened? There isn't anything new about that issue from the first appeal. That was what you argued the last time around.
Well, the two things that are fundamentally different about that, first of all, is the recusal issue was not part of that, because the $25 million incentive not to recuse didn't exist the last time this case was before you.
Other than that, your argument about the documents, that was made the last time too.
No. But the question, what we know is that even after this case went back, after the remand, we know from Mr. Schenker's statements to us that additional statements were being made by Major League Baseball, by the commissioner, to this panel. And the question is, in the circumstances in which this case arises, where this court's already said that the way Major League Baseball has treated the Orioles is evidently partial.
Say that, counsel. That is not what this court said. This court said the attorneys were the ones that created the conflict. Not you chose this. When you chose this panel, before any of this started, you knew exactly what this panel was. You knew who was going to be part of it. And in fact, 3 different teams are part of it now. So there was nothing about the panel. It was about the attorneys. So when you say this court held, that's not right.
Well, but what Justice Marks said, and what this court did not dispute, was that Major League Baseball had a full and fair opportunity to correct the problem that Proskauer created. And that part of the fundamental unfairness of the entire process was that Major League Baseball did nothing in the face of multiple efforts to take Proskauer out of the picture. So the idea that MLB is completely free and clear of any of that taint is nonsense, because they are the ones who allowed that process to go forward without giving us any opportunity to
This sounds
deal
like
with the
the last
recusal
appeal,
issue.
though, rather than this appeal. I mean, you lost that argument already. You lost that argument when the majority in the last case held that the RSDC could decide it.
But the question is, but what they didn't decide, they said the last time that the RSD was fine, and they said that this should go back to the RSDC. But that doesn't mean that the RSDC, once it goes to every arbitration panel, has an obligation, an issue before it as to whether or not it should retain the case. It's not as though this court ordered the RSDC to decide the issue under all circumstances.
Counsel,
very seriously.
Yeah, I'm
if I
sorry.
can finish that point, but go ahead.
Yeah, when I hear you, suggesting that there's this reason that may muddy the water, or this reason that, but I don't hear anything that demonstrates that there's evident partiality. That's the test that we have. There was evident partiality when both sides of the coin were represented by Proskauer before. There's no, I mean, you're talking about statements that you did have some discovery. You don't necessarily have to have every piece of discovery you want. That's how discovery is usually controlled. You're talking about the $25,000, which Orioles knew that there was a loan, and it seems that was sort of holding the status quo, keeping the status quo, and it was going to be repaid. I still don't see how the things you're saying shows clear and evident partiality on the part of the RSDC, and that's really what you need to demonstrate.
So let me try again. First of all, our request
don't
isn't
try
for
again.
discovery.
Your time is up, so you can try on your rebuttal. Thanks. Mr. Neuwirth.
Thank you very much, Justice Renwick and Your Honors. As I believe was reflected in Your Honors' various questions to appellant, this is a case where the fundamental question is whether Justice Cohn, in his detailed and reasoned opinion, correctly found that appellants had not met their extremely high burden of being able to demonstrate an actual grounds for vacator of the RSDC's award, and whether he therefore correctly held that it was appropriate to confirm that award. And not only was Justice Cohn's decision a reasoned and detailed opinion that went through each of the arguments that have been raised on this appeal, but the RSDC's 50-page decision was similarly a reasoned and detailed opinion that we would respectfully submit cannot be legitimately questioned for having done exactly what the party's contract contemplates the RSDC would do, which is, under Maryland law, to apply its established methodology for determining the amount of rights fees that were owed to the Nationals for the years 2012 to 2016.
Counsel, this is Judge Scarpula. How do you respond to the argument that the $25 million loan fundamentally changed and created an inescapable conflict?
We respond by saying that argument is wrong for multiple reasons. The first is, as Your Honors noted, much of this argument is really what was already addressed by this court in 2017 when the $25 million was already outstanding. And what the Orioles had argued at that time was that they believed that the fact that $25 million was outstanding would affect the substance of what the RSDC would do in its decision. Their argument was that this would cause them to award more than $25 million to the Nationals so that they could get that money paid back. And to address that, we noted at the hearing that we would be willing to put that money in escrow. So if at the time of the decision, the award was less than $25 million, that money could be drawn down from the escrow account without any question. As Justice Cohn noted, by paying the money back in its entirety before the hearing, Justice Cohn's exact words were, "We did one better than setting up an escrow account, because now what we did was just pay back the money completely, and we can, for the purpose of eliminating any argument that the Orioles might try to make that Major League Baseball or the Revenue Sharing Decisions Committee somehow had skin in the game. We eliminated that. And we should note as well that I think one of the key facts that Mr. Phillips did not mention when he spoke about how this might have affected the decision of the RSDC whether to recuse itself is that, first, that same argument could have been made with the escrow account. They could have said, well, because the escrow is there, the only way to draw down on the escrow would have been to reach a decision. But I think more importantly is that Justice Cohn, in his opinion at page A23 of the appendix, noted expressly that he said, quote, the Orioles ignore the fact that the RSDC did consider and reject the argument that it should recuse itself. In addition to citing the first department decision, that is the 2017 decision that your honors referenced earlier, he said, the RSDC evaluated in detail the facts relevant to recusal and concluded that there were no grounds for recusal. And so Justice Cohn then noted, while there might be extreme cases in which the court would not accept a tribunal's self-evaluation of its own manifest conflicts of interest, this is not such a case. The Orioles' case for recusal was thin and speculative. So, as I believe Justice Renwick noted and others noted in the questioning, and as Justice Cohn found, the situation here is not remotely comparable to what happened with Proskauer when, as one of your honors noted, Proskauer was found to be, as you put it, on both sides, representing both the Nationals and Major League Baseball and interest of the old panel. This is a completely different situation, and we believe that Justice Cohn went through each of the arguments that had been made. As I think your honors noted, the courts give tremendous discretion. New York courts have repeatedly said that arbitrators have tremendous discretion in discovery decisions. And I believe that this court in its 2017 decision noted, as Justice Cohn pointed out, that the party's contract here does not even give any discovery rights to any party. It says that the Revenue Sharing Definitions Committee will make this decision, but there's no contractual guarantee to discovery. And I think at bottom, what we have here is a situation where the RSDC did exactly what the contract said it should do, but the Orioles disagree with the outcomes that were reached. And we know that in New York, that is not the standard for reversing an arbitration award. And in fact, if it were the standard, the courts would really be involved in looking at every single case. And I would just note in closing here that, in fact, in this case, if you actually look at what the RSDC did in almost all of its pretrial rulings on the merits of the case, it very frequently ruled for the Orioles over the objections of the Nationals, including to delay the hearing for many months at the Orioles' request, which the Nationals strenuously objected to. And the amount of money that was ultimately awarded here was much closer to what the Orioles had proposed than what the Nationals had proposed. So in theory, the Nationals may have had a lot more reasons to complain about this award than the Orioles did. And it should be noted that even though the award here to the Nationals is significant, it pales in comparison to the hundreds of millions of dollars that the Orioles have received during this same period under the parties' agreement. So we know that New York is a state that people look to be able to arbitrate with certainty. And unless your honors have any further questions, we will rest on our papers.
Thank you, Mr. Neuwirth.
Thank you, your honors.
Rebuttal, please.
Let's make sure that my system's working first.
We hear you.
Okay, excellent, thank you. First of all, the more telling relationship between the second RSDC award and the party's position is that the second RSDC award was within 0.2% of the first RSDC award. And as Judge Acosta told you, if you send this back to another panel, you will get exactly the same result. And that is exactly what happened in this case. Now, we did indeed agree to the RSDC, but the Federal Arbitration Act guarantees us a fair and impartial panel with respect to every major decision, and that includes the question of recusal. And on pages A9, 53, 54, and 55 is the RSDC's opinion on recusal, and there is nothing in there about the $25 million thumb on the scale of the disposition of that issue. It relied upon this court's decision that it was appropriate to allow the proceedings to go forward. It says nothing about why that $25 million doesn't essentially guarantee that they have to deny our request for recusal. Our position was not that this is a discovery problem. This is a disclosure problem. Fair and impartial arbitrators have to disclose if they have issues. And in a situation where the relationship between MLB is as polluted as it is in this case, and we asked for them to disclose what they had been told by MLB, we were entitled to have that disclosed to us in order to ensure that we would receive a fair and impartial decision out of this body. And at the end of the day, the last thing you should do is whatever else you say, this is a declaratory order. The court should only affirm it as a declaratory order. This is not a basis for monetary judgment, Your Honors. Thank you.
Thank you. Thank you both.
Thank you, Your Honors.
Justice Friedman should be back any minute. I see him, so I think he's here. Are the parties for the next case assembled here?
Are both attorneys here in Pullins?
Yes. For the respondent.
Yes.
Okay, so we just need Justice Friedman.
Justice Friedman? Can you hear us?
I don't even see his picture anymore.
He's signing back on.
Okay.
Modern technology works for the most part, but sometimes we just have to be patient. We're still working on it. Haven't forgotten you. I see him. His photo, anyway.
Do you hear me?
I hear you, David, yes.
And you see me?
I do not see you yet.
How about now?
I see your photo, but I do not see you. Sometimes it takes a little while. Yes, okay. Good luck, everybody.
Okay.
I think Justice Kern will be back momentarily. I'm signing off.
Okay.
I think we're ready.
Ready? Okay.
I'm sorry, Judge Friedman, are you ready, Justice Friedman?
Just give me a moment and I will be. Pollins versus Naicha. Appellant, please proceed.
Good afternoon. May it please the court, my name is Andrew Lupin and I represent the New York City Housing Authority in this matter. The petitioner is not entitled to succeed to her mother's public housing lease because her mother, Lakeisha, officially removed her from her household composition in accordance with Housing Authority policy, which she was entitled to do as the tenant of record. The administrative record shows that Lakeisha repeatedly and deliberately informed management over the course of 2 years that petitioner vacated the household. Not only did Lakeisha submit 2 separate family member removal notices stating that petitioner had vacated the apartment, as well as a request to transfer to a smaller unit, she also submitted documentation in support of the removal notices, including a notarized declaration stating that she was not aware of petitioner's whereabouts, as well as an order of protection, which was signed by a judge in the petitioner's presence that mandated that the petitioner stay away from Lakeisha's home. The record shows that Lakeisha visited the management office on multiple occasions in order to effectuate the removal, and Lakeisha subsequently confirmed that she was the sole occupant of the apartment when she submitted her annual affidavit of income more than 1 year after petitioner vacated, in which she stated she was the sole occupant of the apartment. The lower court held that the Housing Authority's reliance on all of these documents was arbitrary and irrational because it was, quote, grounded only on one set of statements of the tenant of record and did not take into consideration 2 psychological assessments that management was not privy to and would not have been privy to. The lower court's holding is incorrect for a variety of reasons. First, the lower court's characterization of Lakeisha's statements as isolated is false. Lakeisha made several representations to management throughout October of 2011, in March of 2012, and then again in February of 2013. Also, the order of protection is not a statement of the tenant of record. It is a legal document that would have subjected petitioner to criminal prosecution if she violated it. Second, Lakeisha submitted precisely the documents that the Housing Authority requires in order to remove an individual from a household. There would have been no reason for her to submit any other types of documents than what she submitted. Third, the psychological assessments that the lower court relied on, as I mentioned earlier, were confidential evaluations that the Housing Authority would have had no reason to ever know about, And so they certainly couldn't have relied on those documents when determining who was a member of the household. Fourth, the psychological assessments predate several of the documents that the tenant submitted to management in which she stated that her daughter didn't reside in her apartment. The psych assessments were dated in January of 2012, which is before the second family member removal notice was submitted in March of 2012. And it's also before the affidavit of income that was submitted in February of 2013, where the tenant stated that she was the sole resident of the apartment. So even assuming that the assessments were accurate with respect to petitioner's whereabouts at the time that they were written, they can't contradict Lakeisha's subsequent representations to management. Fifth, although the assessments mention petitioner in passing, they were not created for the purpose of informing anyone about where petitioner actually resided at the time, let alone where she was authorized to reside. And so they are not probative, especially in contrast to Lakeisha's signed statements about precisely this issue, which she submitted for the purpose of informing management where her daughter was not residing. Sixth, the psych assessments are hearsay, and so they really have limited evidentiary value. They're just ambiguous notes taken by third parties about something that Lakeisha supposedly told them, and so they have significantly less evidentiary value than Lakeisha's own notarized declarations. The housing authority relies on the statements of its tenants, not in statements of random people that the tenant has spoken to at some point. And last, the accuracy of the assessments is suspect. One of them gets the age of the daughter wrong. Neither of them even mention the order of protection, which certainly would have been a relevant piece of information. So for all of these reasons, the record is very clear that the hearing officer considered the documents that were actually presented to management and didn't consider there's also nothing in the record to indicate that after petitioner was removed from the household that the tenant or anybody else requested permission for her to rejoin the household or in any way indicated to anyone in management that she was there. So the substantial evidence supports the hearing officer's conclusion. The hearing officer is discretional, so the lower court is to be reversed.
Thank you. Respond.
Good afternoon, Your Honor. Can you hear me? May it please the court, Emma Rosenberg from the Legal Aid Society. I'm getting a little feedback. Friedman, I don't know if you're not muted. I don't know.
I think it's better now.
Okay. May it please the court, Emma Rosenberg from the Legal Aid Society on behalf of petitioner respondent Jaquel Poland. Your Honor, this court should affirm Justice James's decision, which annulled NYCHA's determination denying my client's remaining family member claim and remanded the case for a new hearing before a different hearing officer for the facts presented in this case to be properly considered, as the hearing officer ignored these facts as irrelevant. As Justice James held, the hearing officer's decision was arbitrary and capricious because it applied the wrong standard. The hearing officer rigidly relied solely on a few documents that purported to remove my client from the household's composition and ignored the plethora of evidence in the record showing that my client was born in the subject apartment, that she continuously resided in the apartment for her entire life.
Judge Kern, why wasn't the housing authority entitled to rely on the uncontroverted affidavit submitted by the tenant of record that she was no longer residing in the apartment?
Your Honor, the rule in this department under McFarland and its progeny and under the Court of Appeals Murphy case is that the totality of the circumstances of a particular case could provide a basis for relieving a remaining family member applicant of technical noncompliance with certain succession requirements. And the problem is that the hearing officer failed to apply this standard. Instead, she relied exclusively on the few documents submitted by the tenant of record that purported to remove my client from the household composition, but ignored the plethora of evidence that showed that these statements were categorically false, and also consistent with my client's mother's severe mental illness, which included 10 attempted suicides, multiple serious mental health diagnoses, and a pattern of lashing out against those who were closest to her. And the person who was closest to her was her daughter, my client, who was her sole caretaker. And the record shows that at the same time that my client's mother was representing to NYCHA that my client had vacated the apartment, my client's mother was making contemporaneous statements to her social worker and her psychiatrist that my client lives with her, that she always has my client nearby in the house to care for her when she's overwhelmed by her depression, that my client had to drop out of high school due to the number of absences needed to care for her mother. Additionally, NYCHA's own records show that at the same time that she was representing that my client had vacated the apartment, that she actually continued to reside in the apartment. And this begins with NYCHA's rejection of the first removal notice, which was supported by the temporary order of protection, but which NYCHA rejected because they found that my client must have been living in the apartment because she was the only one with an income. And the second removal notice that was submitted by my client's mother was after the expiration of the temporary order of protection, and it did not include any documents corroborating her claim that my client had vacated the apartment. In addition,
so this is Judge Scarpula. So there's evidence on both sides, right? And the housing authority decides that this evidence is more compelling. That doesn't mean that it's arbitrary and capricious. It means it made a decision that some evidence is more compelling. A party's sworn statement and an order of protection against the daughter is more compelling than some hearsay statements from other people. That's not arbitrary or capricious. How could it be?
Your Honor, the problem is that's not what happened in this case. The hearing officer relied solely on those representations, but completely ignored and failed to consider all of the other evidence. And the rule in this department is that the totality of the circumstances must be considered, and the policies and rules of the NYCHA succession policies must be applied in the context of the particular facts and circumstances of this case. And while on one side, there are a few representations by my client's mother who suffered from severe mental illness that her daughter had vacated, on the other side is a plethora of evidence, of much more evidence than just those few representations showing that my client continued to reside in the apartment. This case differs from those cases that NYCHA cites in its brief, where an authorized family member is removed from the composition and then returns to the apartment and fails to obtain NYCHA's permission to rejoin the household. Because in all of these cases, which we discuss in our brief at pages 33 through 36, there is clear evidence that the person actually moved out of the apartment and resided somewhere else, or the person is not able to present sufficient proof to show that they continuously resided in the apartment to overcome the deficiencies in their case, but that is not the case here. Here, the evidence shows that my client was born into the subject apartment, that she continuously resided in the apartment for her entire life, that when her mother died on July 1st, 2013, she was the one who found her mother's dead body in the apartment. This case is really the perfect example of why the Murphy and McFarland totality of the circumstances principle is so important, and why it is really necessary for the agencies and the courts to really consider all of the facts and circumstances of a case, and not just decide cases based solely on technical compliance with certain requirements. Jaquel Poland is precisely the type of person who the remaining family member policy was designed to protect. She's a lifelong resident of the NYCHA apartment who had to shoulder the devastating blow of losing her mother at an early age, and who should be allowed to remain in the only home she has ever known. Besides the representations by the severely mentally ill tenant of record to NYCHA, there is not a single piece of evidence corroborating her statement that my client ever moved out of the apartment, and that is because she never did. The vast majority of the administrative record, including statements that my client's mother made to her social worker and psychiatrist, including a series of verified family court petitions which state under penalty of perjury that my client continued to reside in the subject apartment, including NYCHA's own records, including the credible testimony under oath of my client and her grandmother, all show that my client lawfully entered the apartment, that she continuously resided with her mother in the apartment for her entire life, and that she should be entitled to remaining family member status. And because the hearing officer here ignored all of that evidence, rigidly relied exclusively on one set of statements by my client's mother, this court should affirm Justice James's decision and remand the case for a new hearing before a different hearing officer.
Thank you. Appellate, you have two.
Yes, I think a misconception that both the lower court and petitioner seem to have is that actual occupancy is relevant to this inquiry. It's not. The Housing Authority's remaining family member policy requires that in order to show that you are eligible to succeed to a lease, you must be listed on the most recent affidavit of income of the tenant's death. And you have to have been an authorized occupant of the apartment for at least 1 year of death. 1 year. Here, the way to remove somebody from a household is to submit a family member removal note, which is what the tenant did, and to provide a substantiation in the form of either documentation, which was the order of protection, or if no documentation is available, then a tenant can self-certify by signing a declaration. So to minimize this evidence is kind of absurd because it is exactly what the Housing Authority requires in order to remove someone from the household. The fact that Jaquel Pullins was not on the income for the tenant's death is sufficient to establish that she is not eligible for family member. The cases that petitioner cites, McFarland, Murphy, and a few other cases that have ruled against the Housing Authority in a family member context, all involve cases where management knew or should have known that an individual was residing in an apartment and failed to take any action in order to remove them. In this case, the record is uncontroverted that no one in management had any reason to believe that Pullins still resided in the apartment. Even assuming she did, and I am not assuming she did continue to reside in the apartment. But there was no basis for management to know that she did. So therefore, none of those decisions are relevant to this case. The relevant decision is the Mr. v. NYCHA case that we cite in our papers, which is directly on point and similarly involved a tenant that removed a household member who had been there all their life and submitted a declaration stating that they were no longer a member of the household, and therefore they were not entitled to succeed to the lease. The tenant has the agency to determine who is a member of her household, and that also involves whether or not the former household member would be entitled to succession rights. And here, regardless of whether or not she was diagnosed with depression, she had the agency to do that. And the hearing officer properly relied on the documents that management was aware of, not on documents that management had no reason to even know existed. And the court has no further arrest.
Thank you. Thank you. Appellate versus Kirschenbaum.
Good afternoon, Your Honors. Daniel H. Richland for the appellant. This is a very straightforward case. There's a $275,000 note that runs at a 16% facial interest rate. There's 3 additional loan charges at the origination of this loan, an $8,250 origination fee, a $1,500 doc prep underwriting fee, and a subsequent $8,250.
This wasn't an owner-occupied. Is that correct?
That is correct, Your Honor. Right.
So the standards are what gets included of deciding what's usurious. Isn't that so?
The standard for what constitutes usury is essentially any charge that's retained by the lender. That's a statutory standard under the New York GOL and under the banking law 14A-2. The fact that 3 New York CR section 4.2A has a specific standard for owner-occupied 1 to 2 family loans And then there's 3 New York CER section 4.2b, which applies to everything, everything else. And
so counsel,
Subdivision A.
I'm sorry, I couldn't hear that, Your Honors.
Subdivision A didn't.
When I made the original motion, I did reference 4.2a erroneously, but I was making a larger point about usury. The specific section or subsection in the CR doesn't change the fact of whether these specific charges are interest. That's the question. Is a 3% origination fee interest?
That's not right, counsel. There is a different standard between non-owner occupied homes, specifically because the bank is at a greater risk for non-occupied owner homes. So the statutes are not the same. They are different.
Are you referring to 3 New York CER section 4.2b? Because that standard just says for everything that's not an owner-occupied 1 to 2 family home, it's whatever it was under the laws that existed in 1968, and it's anything that's retained by the lender. That particular standard, it makes very clear that origination fees are interest because we have banned realty. A Court of Appeals case dealing with a corporate loan, which would be a 4.2b loan. I think the case law is really, really clear that anything that's not an owner-occupied 1 to 2 family home loan is going to fall under 4.2b, and that includes pretty much all of our usury case law. And that's why when we're looking at the standards, an origination fee under banned realty, the discount, the points, that's interest. You're paying down an interest rate. How do you pay down? Yes, sir.
Justice Shulman, as I understand in the record, the actual loan agreement makes it clear that it's charging 16%, which is forgive the term, kosher interest.
Yeah, the maximum possible.
And the agreement makes it clear that they do not want to run afoul of the usury provision.
Correct.
We also know that there were certain fees that were incurred to investigate your client, the origination fees, etc. Sort of like paid for services, not interest.
So here's my explanation.
And when you have regulation 4.2a that addresses owner-occupied residences, where these fees that would otherwise be service-oriented fees, that statute specifically considers that as part of it, whereas 4.2b does not. So then
it actually doesn't say that, Your Honor. What it actually says is 4.2a says these charges, they are interest. And then in 4.2b, it says we're not changing the law. Whatever was interest before is still interest. So I think the misnomer here is that the lower court didn't seem to understand that 4.2b, which applies to a wide variety of loans, not simply just, 1 to 2 family homes that are not owner occupied. It applies to almost everything else. And that's a huge category. Credit card loans, share loans, you name it. It's, all those things are 4.2b. Origination fees are interest. Now, this came on the grounds of a summary judgment. I'm for summary judgment motion. My adversary moved for summary judgment. The problem here is, how does this not raise a factual issue as to whether these charges are interest and usury? They introduced nothing, absolutely nothing.
Councillor, any other questions for? You have time in response.
Thank you, Your Honor.
Good afternoon, Your Honors. Uri Nazarian, may it please the court, represent respondent Winston Capital. For the most part, respondent lies on its opposition brief, but I want to address that appellant's argument that conflates 4.2a and 4.2b is a legal argument. If it fails, which it's our position that it does, that's it. There's no continuum of facts that pushes the needle to denying summary judgment for both parties. Here, we believe that 4.2a and b are different provisions with different standards. Moreover, the pre-1968 case law that deals with cases like this, specifically the Collins case, which was affirmed by the First Department, have held that processing origination fees associated with making a loan are not interest. And that tracks 4.2b, which does not include the language in 4.2a. So if this legal argument fails and there's no other evidence of usury there isn't, the heavy presumption that a note that has a facially valid interest rate has not been, and that not only is sufficient to deny summary judgment in favor of appellants, but is also sufficient to carry respondent's burden for summary judgment. And if there are no other further questions, I'll rest on the papers.
Thank you.
Your Honors, do you have any questions for me? Because I think that was just wrong, but I think I've made my point as to why in the briefs and in my oral argument before. Are there any other questions? No. Have a great afternoon, Your Honors.
Thank you.
Thank you both. Concludes oral argument. Court is adjourned. Thank you.
Thank you.